session. But the goal is to help you guys out with judging. Before I start, just so that I figure out my audience, what is everyone's exposure to moot court like at the current moment?
I can go first. I don't know anything about moot court. I know it's an online, court type situation, and but I'm just being introduced to it now because my son Paul would like to move in that direction, and so yeah.
Good.
So there's
Okay.
that.
And then Mrs. Wong, Mrs. Ko, Mrs. Ariani, have y'all judged yet?
I haven't judged. I'm always very, very slow to get my feet because I feel like I'm a slow, responder anyway. So, but I'm clerking and I've been looking at the packet and I've been listening to people. So I thought I would love to listen a little bit. Thank you for doing this, Ethan.
Yeah, of course. Not a problem. Same for Mrs. Wong.
Yeah, I judged 2 rounds last tournament. It was a lot of fun. I just think CXing them like nonstop is so much fun. but I had a lot of trouble with the ballot. Like I wasn't sure because I'm not jotting down notes as I'm CXing everybody. I'm just like kind of clicking things that maybe they put points, but then I don't know how do you evaluate who wins, who. They're also isolated, like they didn't work together. Like I don't really understand this.
Those are real concerns for sure. I struggle with it myself, but I hopefully will have a little bit of help. Yeah, Mrs. Ko.
Yes, I did judge. That was my first tournament to judge, although I've been involved with it a little when Emma was your student, when you coached Emma, and went to Mr. Speed rounds and stuff years ago. But so just to piggyback off what Mrs. Wong said, that's my concern. My big question is what are we looking for? What wins the round? That was my big thing.
Sure.
Who do you give a win? Like, who do you give a win to?
Sure. Yes, fair enough. Okay, I just threw together in the last 10 minutes before this call a really short PowerPoint just so that I could keep myself focused and on track. So I'm gonna start this. Okay, so we'll cover a couple of things here. We'll cover, obviously, I don't want to speak too much below everybody's level, but I do want to make sure I cover all the bases. So if I'm speeding through things for some of you, or if I'm doing the opposite and not going fast enough for you, pardon me, but I will do my best to try to strike the golden mean here. Okay, so before the round, obviously, you want to read the packet and the bench brief. The judges are the only ones that get the bench brief. The students don't get the bench brief. Obviously, students could rip off of their parents' bench brief, but it's really just for the judges. So the bench brief is found in the moot court library, and it has some pre-planned questions. Me and Anthony Severin spent some time drafting those questions, so they are verifiably good questions. But do feel free to use those if you need any help with asking questions. It also gives you a great summary of what's going on in the round. And then for Mr. Rufo's benefit, hold on, I guess I should just skip to the whole next slide. The packet contains 3 elements. It's got the facts of the record, what is called the facts of the record by the competitors. If you're looking for when a competitor references something and you want to look it up, there's the page number at the very bottom of each of the pages in the facts of the record. It'll say page 6 of the case packet, page 3 of the case packet. So when they say page 3, paragraph 2 of the facts of the record, you can find it by looking at the page number and then marking down paragraphs. So it starts by just giving the factual background, the overview of the case, setting out the story, and then you've got the lower court's opinion. So in general, you're going to have a circuit court. So the way that court proceedings always go is you've got your district court or sometimes your trial court. And if the party who lost that doesn't like that, then they're going to appeal it to the next level. In most cases, that's the circuit court. And then after the circuit court is the Supreme Court. In the federal system, that's how it works. So usually we're going to see appeals from the circuit court because that's the level right below the Supreme Court. In this year's case packet, everything happened at the state level because this was a state offense, so he was tried under state law. So Denolf was tried under state law. He appealed it to the state Supreme Court of Olympus, which is the fictional state. And after he lost his case at the state Supreme Court of Olympus, you can appeal that to the federal Supreme Court if the issue is a constitutional issue. So since the claims that he was raising were Fifth Amendment and Eighth Amendment, they are constitutional issues. So you can raise them at the Supreme Court level. So it's not a petition that's coming from the circuit court, but it's coming from the state Supreme Court. Okay, so the packet contains the facts of the record, and then it's got the majority opinion from the state Supreme Court and the dissenting opinion from the state Supreme Court. So since this case, this particular case, the one with the majority and dissenting, is being appealed to the Supreme Court, that means that the petitioner, the one who wants you to change the decision of the lower court, to reverse the decision of the lower court, the petitioner relies on the dissenting opinion because they're saying the dissenting opinion got it right, the majority got it wrong. That's the petitioner. They're saying, please reverse the decision. The respondent, of course, is going to do the opposite. The respondent says, we agree with what the lower court said. We agree with the majority. So the respondent relies on the majority opinion. The petitioner relies on the dissenting opinion. Now, obviously, they can have any sort of disagreements they want with their own side, but they generally are going to use the same arguments. And the lower court opinions are always persuasive precedent, as in the Supreme Court takes stock in those, but they're certainly not binding precedent, of course. That's why the Supreme Court is reviewing it. But it is still, in some sense, persuasive. It's similar to, if a pastor says something, as Protestants would say, if a pastor says something, you need to test it against the word of God, but also it carries some persuasive merit. So you have to listen to it, but it's not officially authoritative. Okay, so that's your duties before the round. Duties during the round, of course, is taking notes. The way that I'm taking notes is I'm doing it on my computer on my notes app, but you could pull up a Google Docs and do that as well. I find that it's easier to take notes on the computer than on paper, just because I can type substantially faster than I can write. But it's up to you if you feel that it's easier to write. Obviously, you're going to get to ask questions as soon as a minute expires. So the competitors have a minute of protected time, which is what the clerk is clapping for. After the clerk claps, then you can ask as many questions as you want. And judges are completely free to interrupt the speaker at any time, including in the middle of their sentence, in the middle of a word, in the middle of a syllable. You can interrupt the competitors at any time. There's no specified time for you to ask questions. It's just throughout the flow of their speech. And the last thing I wanted to remind everyone was that you are in control. So if you want anything to happen differently, you can say so. I have always thought when I was a competitor, when there were some speakers that were speaking too fast, I was just thinking, when I'm a judge, I will tell them to speak slower. And I haven't yet had to do that, but you can do that because you are the judge. You can tell them, hey, could you slow down a bit because I can't understand you. You're totally free to do that. Same thing with point structure. I asked a competitor in quarterfinals to switch the order of his points because he started with testimonial on the Fifth Amendment issue and then moved to compelled. And I figured the respondent's going to do the opposite. So I wanted him to mirror what's going to happen on the respondent. So I said, could you start with your second point and then go to your first point? And they're like, of course, Your Honor. And then they just went straight through that. So don't feel constrained by anything. You're in control when you're the judge in the round. In terms of questions, there are three main types of questions that you can go for. The open-ended questions, they're pretty simple, self-explanatory. What do you define compelled as? What would you say to this court case? What is your response to their argument here? Open-ended questions. Closed-ended questions is when you have an argument already. When you know you have something, you want to know what they think about that. So you could technically phrase it as open-ended, but it's very strong to phrase it also as a closed-ended question. So let's say that I know that when Mr. Denolf sat for the FBME test, I'll explain the case packet in a bit, but just hold on, just be patient for a little bit. So when Mr. Denolf sat for the FBME test, he technically could have closed his eyes so that the FBME didn't work on him. So my argument to the the petitioner could be, couldn't Mr. Denolf have closed his eyes or couldn't he have left? Now that's a closed-ended question because it's a yes or no question. Couldn't he have done this? Couldn't he have done that? Of course, they're going to say a yes or no and then continue on. But those closed-ended questions come off much stronger than, what do you think about the possibility of Denolf closing his eyes? Just give the argument with a nice tie-in. Also, and this goes with control, feel free to tell the competitors that they didn't answer your question. Like, let's say I say, couldn't Mr. Denolf have closed his eyes or left? And they start talking about, oh, Miranda rights, but he wasn't read his Miranda rights, and Miranda rights are really important. Sorry to interrupt you, counsel, but I'm just asking if Denolf could have closed his eyes or left. You don't have to feel rude about this. Competitors like being questioned, as long as you're not like belligerent and extremely rude about it. But like, if you say, sorry to interrupt you, but actually my question was actually just, couldn't Mr. Denolf have closed his eyes? Not about Miranda rights. And asking that question is totally within your purview. The third thing is not technically a question, but you can make arguments and wait for them to respond to it. This actually happens a lot at the Supreme Court level when you listen to oral arguments. The justices are not always asking questions. Sometimes they'll just say, I'm worried about the fact that if we overturn this case, that will make us look like a political body. And that's all they say. So then the attorney has to respond to that statement. So you could make a statement and wait for them to respond. You don't have to phrase it as a question. After all, it's supposed to be a conversation. And as you know, if you ever get in a conversation or even an argument with somebody, it's oftentimes you just make a statement and wait for them to respond. So, for example, some petitioners will say like, Mr. Denolf, he already has signs of depression. So this means that it's cruel and unusual punishment. You can just say, I'm not persuaded by that argument. Anyone could get depression. And leave it at that. And they would have to respond to that. Okay, any questions so far?
I have a quick question. This is Paul.
Go for it.
When the lawyers are arguing their case, are they going to be bringing up case law that is going to defend their position? And if they do, will we get a brief with what that new case law is? Because I know sometimes lawyers like to bring up nuanced stuff about how a different piece of how case applies and how it will shape what they think the outcome should be.
Yeah, that's a good question. And you pointed out something that I neglected, which is that in the packet, it includes the facts of the record, the majority opinion, and the dissenting opinion. And at the very end is an appendix with all of the cases that they're allowed to cite from. So they have a list of typically it's 8 cases each issue, and they can only reference those cases.
Okay, so they can't go out of those bounds.
They cannot go outside of those bounds.
Okay, all right, that's very helpful. Thank you.
Now, you'll sometimes hear them reference a case, and then they'll say, as cited in this case. And what they're doing is, if they're reading through a case, let's say they're reading through, Dobbs v. Jackson. Dobbs v. Jackson is going to quote from other cases in Dobbs v. Jackson's opinion. So if Dobbs v. Jackson is quoting from Janus, then the competitor, while reading Dobbs, would say, as Janus held, as cited in Dobbs, blank. That way you know that they're not just doing outside research. You know that they found it in the case that they're supposed to, but it is a case that comes outside, technically, in some sense outside of the packet.
Okay, and last question on that is, can they also say section blah, 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 blah of the criminal code states such and such, and if we compare, and if we contrast that against different case law, they can try to say what that piece of legislation would mean in relation to that case law. Will they go into that? And so will we, if they do, will we have that legislation, all the codes that we can look at?
Yeah, so in many moot court cases, they don't include anything like that, but they have in the past included laws. So they've got the actual text of the state laws that you can reference, but you'll have access to the same materials that they do. In this packet, we don't have any access to laws. I anticipate the next year's packet actually will. So then you'll get access to reading those laws, and then the competitors will also.
Okay, fantastic. Thank you.
No problem. Okay, the last thing is, as all of you are thinking, is after the round, how do we adjudicate the ballot? This is, as you were pointing out, it is a very difficult thing to adjudicate the ballot. So I've been kind of, because I judged at the first two tournaments, but I've judged a couple times in years past also, and I've tried to figure out a system, and I haven't landed perfectly on a system quite yet. But the current system I'm operating with, I'll explain in a second. Before I do, I must explain some history, which is that when NCFCA first started doing Moot, they started by doing it on a point system. So whichever team racked up the most points would win the ballot. And the year after that, they switched to doing it based on who won and lost. So there was not points, they had speaker points, but the judge still voted on whichever team won the arguments. And then they switched back to the point system, which is the point system that we're currently dealing with. I don't know which one you think would be more helpful, but I actually think the point system is ever so slightly more helpful, because in the time constraints that we have with Moot, oftentimes they will not get around to an argument that is crucial to their case. So for example, on the Fifth Amendment, you have to prove compelled and testimonial. You can't just prove one. You have to prove two elements of the Fifth Amendment. Now, let's say that they're in a quarterfinals round and they've got three extremely competent judges, Mrs. Wong, Mrs. Ko, and Mrs. Ariani. And all three judges are giving them so many questions that they cannot finish their second point. They only get to their first point. Well, technically, according to the arguments, they've only proven one half of their case, and they can't just prove half of their case. So they would technically lose on the merits of their argument. So I think it's the correct decision to make it on points rather than on who won or lost the arguments. So arguments obviously do come into account, but it is worth noting that there's a specific reason why the NCFCA chose to make the round based on points rather than based on solely the arguments. Okay, so then how do we adjudicate the ballot? This is an example ballot that I have from one of my students, though 4 is not what I would suggest giving 4 is for. But okay, so here's my suggestion. So when you finish the round, you should go person by person, each issue. So let's say that you start with organization. I'm going to say Speaker 1 had a 7 for organization. Speaker 2 had a 6 for organization. Respondent 1 had 7 for organization. Respondent 2 had an 8 for organization. That way you can compare everybody on their organization. Now, what comes into play in organization? What are we thinking with organization? You could think of a lot of things. Most important to me is organization, according to the bench book, includes the introduction and conclusion. So having a strong introduction and conclusion. But it also means you felt like the points flowed together nicely. You could track the points. And they didn't spend a disproportionate amount of time on one or the other thing. So on the Fifth Amendment issue, if you're asking a normal amount of questions and they only cover the first point and spend 30 seconds on the second point, that's bad organization. Some competitors might think, well, that's because the judge asked me questions. But as long as the judge isn't asking like perpetual rapid fire questions without a break, you have the opportunity to say, now to my second point, and move to your second point. And so organization includes, again, introductions and conclusions, how well you think their points flow from point to point, how much you understand their points, and also how much time they spent on points. Did they spend a disproportionate amount of time on one point over the other? So when you look at the category of organization, then you can compare, here's how this speaker did. Let's say I say the first speaker was like a 7. Okay, well, this speaker, he actually was slightly better because I liked his introduction better, but his points, like his first point was 5 minutes and his second point was like 2 minutes. So those kind of balance each other out. I'll say I'll also give him a 7. Okay, next speaker. I didn't actually understand their roadmap at all. The introduction was a little bit messy, so I'm going to give that person a 5. So that's how you would like adjudicate between, you look at each individual person and compare them on the same point category, the organization category, and then you adjudicate that way. What does knowledge mean? Well, knowledge, argumentation, and response seem kind of similar. So it's kind of difficult to parse out what all the differences between the 3 categories are. It's up to you, but I would suggest that knowledge refers to how well does the speaker convey that he is digested the information from the packet and case law. If the speaker is quoting a lot of case law at you, that generally tells you that he has a lot of knowledge. Obviously, that's not always the case. Sometimes, like if they're quoting cases that don't apply, that doesn't mean that they have very good knowledge. But the more that they stray away from mentioning case law, stray away from mentioning specifics of the record, the less knowledge they have. Oftentimes, the speakers will give you a lot of logic points. Logic is great, obviously, but if they really aren't relying on case law, their knowledge isn't particularly high. For argumentation, here's where I think argumentation comes down to, are you persuaded by the individual arguments they make? So what I do is when the speaker begins, they tell you what they're going to be arguing. They give you their roadmap. You want to write down their roadmap, type out like the key words that they said in their roadmap. And if you find by the end of the round that those points that they argued in the roadmap and the way that they got to those points was more compelling than their opponents, then they're going to get higher argumentation points. So argumentation strictly refers to the arguments that they present as their first point and their second point. So for example, on the Fifth Amendment issue, some people will say, we're going to try to prove that Mr. Denoff was in custody and that makes him compelled. Maybe you like that argument. Another team on the Fifth Amendment petitioner might say, we're not going to try to prove he was in custody because we don't need to prove he was in custody. Maybe that's a spicier argument. So maybe you like that argument better. That's what I'm talking about with argumentation. How much do you buy? How much do you like the arguments that they're making? And again, you compare each of them to their opponents and to each other. Were their arguments cogent? Did they persuade you? Did they make sense? Response. This is strictly about how they respond when you're asking them questions. Now, again, this is why I say that knowledge, argumentation, and response are kind of tied, because often in their response, they'll display if they have knowledge or not. But response, strictly speaking, is when you ask them a question, are they stumbly? Do you feel persuaded by their arguments? Now, notice the difference between argumentation and response here. Argumentation is what they have scripted. Response is how they respond to your questions. And those things are different. So you might like their arguments, but when you start pressing them, they don't know how to respond well. That doesn't mean their arguments are bad. That means their response is bad. Similarly, you might not like their arguments, but they have really crisp, clean responses, higher on response, lower on argumentation. So argumentation is referring to the points that they tell you they're going to make. Response is when you ask them questions. Delivery is pretty obvious. The things that I'm looking for in delivery are not speaking too slow, not like clearly reading off of a script. Obviously having good inflections is part of that too, and also stuttering as well. But those are the things that I'm considering under delivery. But as NCSEA judges, you are, I'm sure, well equipped to tackle what good and bad delivery is. So, okay, any questions about the ballot? Nope, good.
Well, obviously, like this speaks, when we're looking at those ballots, they are giving us like 50 points. We could, give them 50 points, in comparison with, like, say, TP or LD ballot is, whoa, that's a lot. That's a lot. So how do you, like, what is the best case scenario in it? Like, what, say, like, all 50 points, is that feasible for us to even give as many points? Like, what is the lowest side of it and what is the highest? Because sometimes you just go 12 points, but is that even acceptable?
Yeah, that's a fair question, and I cannot give everyone a definitive order because it's all up to you. That's what the ballot is for. In my own experience, I usually start people between a 6 and a 7, depending on how good the round is. And I basically say, if you did something that made me upset about your argumentation, I'm going to drop points from 6. And if you did things that blew me away, I'm going to increase points from 6. You don't have to do that because maybe that means you max out at 8. And you have to be fair because basically what I imagine is, because your question is, should you ever give somebody like 50 points? If somebody finishes the round and you can't think of something that they could have done better in delivery, you can't think of better arguments, you can't think of a better response, you can't think of better knowledge, you can't think of better organization, you have to give them like 49 or 50. Like you can't just arbitrarily subtract points. Now, obviously, that hopefully should not happen because everyone's going to make mistakes. I have given one speaker 50 in my entire life. I mean, you have to be somewhat picky. I'm not suggesting you go around handing 50s to everybody, but that just means that you should be specific about when you notice somebody make a mistake with organization and move on to their second point too fast, or you don't really like the way that they've structured their arguments, or the points don't clearly flow from point to point, all that kind of thing. Okay.
What
yeah.
about the low spectrum of it? Like how low can you go? Like, are there any?
Yeah, that's another like judge discretion question. I think unless they are, I think like 5 denotes your average, what you imagine your average like novice NCFCA, or well, no, not novice, like some maybe like I don't know. I just imagine that 5 is like an average speaker, so like a reasonably competent speaker. So if they are like below competent in these levels, I would give them below a 5. But every team I've seen, I've not given a 4 yet this year because every team I've seen is competent. If they really are like fumbling around terribly, and I don't just mean like, you know, they're stuttering a little bit, like they have terrible arguments, they don't even know how to respond to your questions, they just move on, then yes, give them below 5s. But I would generally stray away from that unless they're not competent. Okay, we will tackle the issues now. So I'll give you a brief overview of what's going on with each of the issues, the 8th and the 5th. I realize I think I started with the 8th Amendment, so oops. So in order, the speakers are going to deliver first 5th Amendment and then 8th Amendment. So that's my bad with the order. So the 8th Amendment reads that the punishments shall never be cruel and unusual. And so the issue that is arising is whether or not the petitioner, Mr. William Denolf, the fact that he is sentenced to 30 years in solitary confinement with particular conditions, if that's cruel and unusual punishment. So what happened is Denolf tortured and murdered and likely raped a woman, a school teacher, and wrote her name on the wall, or sorry, wrote something on the wall with her blood. So what he did was absolutely heinous. The judge had the discretion to sentence him to the death penalty, but the judge said, I'm going to sentence you to solitary confinement. And the judge commented, because he tortured his victim, he deserves solitary confinement. So now Mr. Denolf is entering solitary confinement. He'll be in solitary confinement for 30 years. The conditions of his confinement are interesting because he's in a cell that measures, I think, 7 by 14 feet, which is a very small cell. That's a pretty small sized bedroom. It's completely opaque, so there are no windows, there are no bars. There's just like a wall. There are 4 walls, and he's got his bed. He's got all the basic elements of hygiene. There's not a way for him to communicate with prison officials. Every 30 days, he gets to leave his cell to a recreational facility where he can't see anybody, but he can hear other people because there are some walls that are partitioning him. And then he goes back to his cell. We'll mention some more specific details, but that's the gist of his confinement. So the question then under the 8th Amendment is it cruel and unusual? Now, some speakers like to use a category from this one case they like to say objective and subjective prong of the 8th Amendment. So I'm just going to quickly explain that, but I don't like that language. I tell my students not to use it because it's confusing. The subjective and objective prong starts with the objective prong, which is that if society saw his conditions, would they think that his conditions are cruel and unusual? Now, it's weird that it's called objective because that's technically not objective. But what they mean by that is, aside from the prisoner, what does the rest of society think about his condition? Now, they don't mean to like take a poll either. They just mean like a reasonable society person think of his condition. the second question, so that's the objective prong. The subjective prong is, what is Mr. Denolf himself experiencing? So that's why it's subjective. What is he experiencing? Because even if his conditions are bad, if he likes those bad conditions, if he's like a masochist, then that doesn't really matter. So he also has to experience some subjective pain in addition to the fact that his conditions are objectively dangerous. Now, the fact that it took me like a minute and 15 seconds to explain that means that that's why I don't suggest a lot of speakers use it, but some people do use those categories. I think the Eighth Amendment gives us clear categories. It says it has to be cruel and unusual. So I'm going to tackle those in order. So we'll start with cruel. His claim about cruelty is not that he's being inflicted, not that he's suffering any medical pain, but that he's suffering psychological pain and will suffer psychological pain. And that distinction is crucial because the pain that he's currently experiencing is that everyone agrees, expert witnesses for him on his behalf and on the behalf of the government agree that he has signs of major depression right now. But I think as you'll think about it later, major depression isn't cruel punishment. I mean, I heard a judge once say in response to that, I have major depression. Does that mean I have cruel and unusual punishment? Which is a fair point, that lots of people are going to experience depression in prison. That's not necessarily cruel and unusual punishment. But his claim is not just that the current punishment that he's facing is dangerous, but that the future psychological pain is what is most damaging to him. So he believes after 30 years in prison, in solitary confinement, he will experience severe, debilitating psychological pain. And there are studies from one of the cases in our record that demonstrates. In fact, the study says it was a meta-study that looked at dozens of studies, and they said there is not a single study that found that if a prisoner is in solitary confinement for more than 10 days, he doesn't come out with some sort of psychological illness. In other words, every single person who's in solitary confinement for more than 10 days comes out with a psychological illness. So Mr. Denolf's claim is this is psychological pain. That's what's cruel. Now for the unusual part. Where else is solitary practiced? In order to prove that solitary confinement is unusual, they would need to prove that not a lot of people are practicing solitary confinement, or not a lot of people are experiencing the conditions Mr. Denolf is experiencing. Now, you'll hear very often that people will refer to other examples of solitary confinement in the United States. So on the federal level, there is some solitary confinement that's being practiced. Now, if you look pretty closely at it, it says that the solitary confinement is being practiced for administrative and disciplinary reasons. 84% for administrative reasons, 16% for disciplinary reasons. Notice that neither of those are punitive solitary confinements. Both of those are logistical solitary confinements that are imposed by something other than a punishment. So I don't think we can say that because the federal government practices solitary confinement that it's not cruel and that it's unusual, because the government doesn't really practice solitary confinement. They practice administrative and disciplinary segregation. Okay, but what about the state level? Because it does say that 20 states practice solitary confinement without definite release dates. That seems to indicate that it's not very unusual. Now, there are a couple of ways you could go for this. Now, some people have said, okay, 20 states practice it, but it's still pretty rare in those 20 states, so it's still unusual. I don't like that argument because the death penalty is also rare. That doesn't make it unusual, like cruel and unusual. A better argument, I think, to the state's argument is, we're not just contending the length is unusual, we're contending the conditions are unusual. Because remember, Denolf is saying that what's cruel about his punishment is the psychological pain. He's not just saying the length, but also the conditions of his confinement. And one of the cases that we have in our record examined death row inmates in solitary confinement in Virginia. The case is called Porter v. Clark. And in Virginia, solitary confinement inmates were allowed to call anybody from 8 a.m. to 9 p.m. They were visited by prison guards every 30 minutes. They had a mental health professional check up on them at least once a week. And they could write letters to their family, all that kind of stuff. So they had substantially more of ability to have human contact than Mr. Denolf has. In Mr. Denolf's case, guards don't circle his cell at all. In fact, the only way that guard would know if he's in pain, whether it's medical or mental health pain, is if they see it on a surveillance camera, because they've got a surveillance camera on him. But is that sufficient to be able to see if somebody has medical or mental health needs? I don't think so. So the unusual is not just the length, but it's also the conditions, namely that Mr. Denolf is experiencing a high amount of unusually cruel conditions, namely deprivation of human contact. He doesn't really have any human contact. That's what's unusual, because even in other solitary confinement places, they still have human contact. Before we move on to the Fifth Amendment, any other questions? I am going, since I do not have Zoom Premium, our time is about to expire. So I'm going to end this call. You can click the same link to rejoin. So I will see
Thank
you.
you, Ethan. I'm going to not come back because I've got to go do something, but thank you so much. I appreciate
No
it.
problem. Talk to you later. See you all in a minute.